Good morning. Welcome to the First District Court of Appeal. We have one case on the docket this morning. It's Representative Larry Metz et al. Versus Matt Media, LLC, and Charles Pat Roberts. I see that both counsel are present. So, counsel for appellants, Mr. Tannenbaum, you may proceed when you're ready.
Good morning. My name is Adam Tannenbaum. I am General Counsel for the Florida House of Representatives. I request that the court allow me 4 minutes for rebuttal.
So noted.
May it please the court. The House has sought to ensure accountability and transparency in the use of public funds for tourism marketing. Against the backdrop of its consideration of related legislation in 2017, the House sought information about Visit Florida's no-bid public contracts with Matt Media, for which Matt Media was paid millions in public funds to produce Emeralds, Florida, a tourism advertising campaign done for the state.
Hey, do you mind? I want to first focus on what items in the subpoena are still in dispute. And I want to start with what I think is a common theme of the House, both below and on appeal, that it is not seeking any of Mr. Roberts' personal records or information. So if we look at the specific request, let's start in reverse order. Paragraph 20, which was directed solely to Mr. Roberts, requesting income received by him in connection with production and airing of Emeralds. Is that still on the table?
No, Your Honor. Thank you for asking that question so we can clarify. At a minimum, it is, and I say minimum, paragraph 18 in each subpoena covers what we're looking for. It's broad enough, and it's specifically the records concerning the production and airing of Emeralds, Florida for the years 2012 through 2017. The reason I say that is broad enough to cover, I noted in a footnote in a brief that I missed the misstatement in court that paragraph 16 or 17 were not at issue. They are. That wasn't resolved, but 18 would cover 16 and 17. The paragraph 20, Mr. Roberts' personal records or financial records, his tax returns, we're not contesting.
Okay, so paragraph 20 is off the table for purposes of our analysis. So let's also focus on paragraph 19, which was directed to both Matt Media and Mr. Roberts, and asked for Matt Media's federal tax returns for, I guess, a 4-year period. Now, the record shows that Matt Media does not file individual tax return. Instead, its disclosures are on Mr. Roberts' tax return. Is the House still pursuing the items in paragraph 19?
No, Your Honor. As it turns out, we learned in the hearings, and it's reflected in the record, that it sounds like it's a Schedule C on Mr. Roberts' personal tax return. That's not, we've taken that off the table as well. We're really focused on the records requested in basically paragraph 18, but 16 and 17, which are included in 18.
Okay, I appreciate that. No, I was just want to thank you for that clarification. That was very helpful.
And what are you looking for 18? Or is all you're looking for the actual cost of producing the Emerald show for what was paid in Emerald? I mean, what is actually the House looking for here?
Well, as part of the House's investigation into the Visit Florida contracts and how Visit Florida negotiated and priced the contracts with Matt Media, they were looking for the cost actually incurred to produce programming like Emeralds, Florida, which is produced with public funds, to get a better idea of how these contracts are negotiated, whether it was priced appropriately, and whether the House, if there's any legislation that can be adopted to make these contracts much more transparent. So in these records, and the records that the House is seeking are actually in the court file under seal. They were provided to Judge Gievers for in-camera review, and they're in the record under seal. So they're already identified, they're already available and collated. And those costs, those records will show the actual the costs that go into the production of this programming. And as it turns out, Matt Media is the only source for that information. And the House needs it. The House is looking for it so it can make its own assessment as to how this pricing is done.
Don't you have that information already to a certain extent? I was reading the deposition transcripts, and I believe the chief marketing officer of Visit Florida at the time, I mean, he said, we really don't take costs into account. We look at what we determine based on experience and perhaps comparable productions to assess the fair market value. So does that not tell you all you need in terms of whether cost played a factor?
No, Your Honor, and actually that highlights the need for the House to actually get these records. Mr. Phipps testified that they actually don't specifically look at what the costs are. It's more of like a subjective gut check based on his experience. He talked about his 30 years of experience. The quote at the beginning of our initial brief shows that basically it's some people in Visit Florida that get together, they look at the quoted price from Matt Media and similar contracts for similar vendors and decide, yeah, that sounds like a good price. Florida House doesn't have 30 years of experience in tourism marketing, so the Florida House doesn't have access to that information on its own. That it was seeking these records to understand, to get behind what Visit Florida is saying is, yeah, that's a good price, to understand, well, is it in fact a good price? In a broader picture with tourism marketing and how Visit Florida was engaging in these contracts, Florida House is investigating, is Visit Florida doing a good job? And Visit Florida is funded with millions of dollars of taxpayer funds every year. Visit Florida is was tasked by statute with being the tourism marketing entity for the state of Florida. It was responsible for going out there, finding contracts, doing tourism marketing on behalf of the state of Florida. Visit Florida exists because there was a statute passed. That is the legislative authority. It's certainly within the bounds of the legislature to establish tourism marketing and to establish this mechanism by which tourism marketing is funded and accomplished. And if it's within the legislative power to do in the first place, it's within the legislative power to adjust, to correct if there are issues, if there needs to be a change. And there's a bill that we put in the record that shows an example of something the House can take into consideration and to add transparency. And the point is that if it's within the legislative power, that's the first inquiry. Is it because the investigative power is coextensive with the legislative power? So the answer to question one is within the legislative power. The answer is yes.
Okay. Does anybody that enters into a contract with the state of Florida expect that all the records related to the transaction will be open and available to the legislature?
I think that is, yes. I think vendors should expect that. And in fact, Matt Media knew that was a possibility, at least indirectly, because Matt Media in every contract it engaged in with Visit Florida agreed that it would maintain these very records in case Visit Florida needed to engage in an audit.
My next question. And does that maintenance of records make a difference in this particular case versus other cases? The maintenance of the records, the audit provisions, does that make it a little different than maybe some other contracts that may be entered into with the state of Florida?
I'm not sure it make it different. It's additional. It's an additional indication that at least with respect to Matt Media and their claims of that somehow this is overreaching, they were on notice. And the reason I said I'm not sure.
And I understand. I kind of understand. But when we're deciding cases, we try to decide them narrowly.
Yes.
And can we decide this case for the House on the basis of that paragraph that Matt Media really had no expectation that these records would not be sought?
And I suspected, Your Honor, that's why you were asking, and I'm familiar with the court's desire to decide cases narrowly where possible. The reason I hesitated is our argument here, though, is that the error that the trial court ultimately committed was engaging in the court's own review of the records and doing this balancing examination like it would do in a discovery dispute.
Okay, that leads me into my next question.
Okay.
Okay. Let's say the right to privacy is not, I know your position doesn't apply here, so let's assume it does not apply. What is the court's job in overseeing legislative requests for information? Because obviously we have some
Absolutely. Yes.
stake in that game.
Yes.
Well, tell me what it is.
Yes. So, and the role actually is, it's reflected in the statute that directs the courts to enforce the subpoenas and require that the records be produced. And it's in there, and it's in the cases that we cited, in the sense that it's lawful requests that are lawful demands from the committee or from the House.
What does
And
that
so
mean?
what is that is the question. So how far does the court go when determining whether a request is lawful? The court, as the Supreme Court did in Hageman, as the Supreme Court did in Gibson, and as courts do, and we've referenced cases in the briefs in investigative subpoenas, the inquiry is really the same in all of it, and that is first ask the question whether, as it already indicated, the first question is the area of investigation within the power of the legislature? That's question one, and so that's a question the court would ask. Question two then is looking at the specific request that is being refused or challenged. Is that request tied to that legislative power? Is there a nexus between the request and the legislative power? And that gets to, there's references about being, can't be overreaching, it can't be a witch hunt. It is enough if there's that connection, if you can make the connection between the request and the power
Well,
of the
just real
legislature.
quickly, and I know you're about to jump into your rebuttal, but the United States Supreme Court in Gibson said there needs to be a substantial relation. And then some of the other cases talk about a nexus, and it seems to be not necessarily as burdensome as the Gibson court set forth. Can you just tell us concisely what the test is that we need to employ?
It is, and Gibson highlights the Gibson case that deals with the NAACP and the seditious activity. So what's interesting about Gibson is that in Gibson, they didn't refute the request. The question that was being challenged and was discussed at length was they wanted the membership list of the NAACP. The court walked through that process and first said, well, seditious activity is subject to legislative regulation. So check the first box. It's within the legislative power. The next question was, not looking at the results of the answer, which is what the trial court did here, is looking behind the question and see what was actually going to be produced. In Gibson and in Hageman, they look at, let's look at the question on its face. And the request of all membership lists, the court could not make that connection. It's like, that seems overreaching. And you see this in some of the investigative cases as well. Like if they request all the entities' records for 5 years, like not having any connection with the request, that's going to be overbroad, and that goes more to a Fourth Amendment challenge, which is not raised here. But the answer, that's the inquiry the court would be doing is first, is there that connection, and then the last part of the inquiry is there some constitutional right being implicated? And if there's not, and there's not here, then that's the end of the review.
Okay, well, you said you should not have looked at the papers here. The only concern I have is, as question 18 is worded, seems pretty broad. Or the request under 18, all journals, books, records, etc. If the House concern here is truly to look at the cost expended, in executing this contract, why shouldn't the court be able to say, hey, this seems pretty broad here. Tell me what your real concern is. I'm going to take a look at it and see whether the things you really want are in here. You understand my question?
Sure, yes, and I know I'm into time, but the short answer is that can be satisfied as a facial review, and in fact, the trial court did that here. The trial court initially said, I don't see any reason why the House shouldn't get these records. It was only after, and so that was a facial conclusion. They didn't have really an issue. And the reason that initially there wasn't an issue is if you look at the face of the request, yes, the request is broad that we're looking for all the records, but it's specifically tied to, and this gets back to what Judge Ray and you, Judge Wolf, both are asking is, how far do you go into the inquiry? Well, you look at the request, and what is the investigation? The investigation is Visit Florida contracts, and specifically regarding Emerald, Florida. We have a request that asks for all the records, but it's to one vendor, and it's not asking for all of Matt Media's financials for 5 or 6 years. It's asking specifically about records dealing with those public contracts, which the House has identified as it's investigating. And that should be the end of the inquiry, and that's where the trial court was initially. It's then there was an in-camera review of the actual records, and it was only after reviewing them that the trial court decided for itself, well, the House doesn't really need those. That doesn't really match up with, or is not going to help the House's investigation. And that's beyond the authority of the trial court to do. It should have stopped at facially, it's acceptable, it's narrowly tailored, it's not asking for all records for all time since the inception of Matt Media. It's specifically tailored, and it has to do with an authorized legislative investigation.
Yeah.
There's not a constitutional right, so that should have enforced the subpoena.
Thank you, counsel.
Thank you.
We interrupted your rebuttal time, so I'm going to give you 3 minutes for rebuttal, and of course, I will extend the appellee's time as well by 3 minutes.
Thank you, Your Honor.
May it please the court, Mark Ahern on behalf of Matt Media and Pat Roberts. The court in its questioning of Mr. Tannenbaum, I think, has put its finger on what the real issues are here, and that's the scope of the legislative subpoena power when they have this asserted ground for the need for it to do legislation or whatever they say they're doing. In their report that they made to the full House when the House issued the House subpoenas as opposed to the committee subpoenas, the committee said they were looking at the integrity of the contracts and the quality of the procurement. What the court needs to understand, which I think it probably does, is these were deliverable contracts. Matt Media did not get paid unless the product was delivered and accepted by Visit Florida. It wasn't like...
Why isn't it legitimate for the House to be looking into whether these contracts should be cost-plus contracts? That in the future, any kind of contract like this should be cost-plus?
Again, that's
Isn't it legitimate, let me finish, isn't it legitimate if you have $1 million, I don't remember the contract figures, but $1 million contract and you only spend $200,000 and get an $800,000 profit, to say that maybe that's unreasonable in the future and we want to control that?
not necessarily wrong to do that, but again, in this context and in the context which I think you brought up initially, is that, does that make every contract that an entity enters into with government subject to the legislative subpoena power to look behind to see what the cost to the vendor was to provide that service? That is not what they contracted for
Well,
here.
to follow up on Judge Wolf's question to appellant's counsel, there was a provision in each of these contracts, though, that required Met Media to maintain basically all of the information requested for purposes of audit later. And so why is this any different than what's required by the contract?
Well, in this case, the contract was between Visit Florida and Matt Media and was for the purpose of Visit Florida making an audit of the contract and things like that. They did not do that. They accepted the product, they paid the bills. So I don't think that that is a controlling factor in terms of this. And in fact,
well, certainly the legislature can oversee Visit Florida and see whether it's spending taxpayer money in an appropriate way, to see whether they got the best price on any particular contract and that sort of thing. So I'm not sure I get what the distinction is between Visit Florida's right to audit and the legislature not having the ability to know what's going on with this contract.
well, again, the legislature has all the documents that Visit Florida has. They got them from Visit Florida. And in fact, but again, the legislature is not the administrative agency, and they could make their policy determinations without this information, to tell you the truth. And in fact, they did, because they did introduce legislation on the House and Senate side that changed the law that would require Visit Florida and to maintain these kinds of documents and to have a statement put in by the vendor as to its cost in any contract over $50,000. Again, they didn't need this information in order to make that determination as to whether they
But
want to
doesn't
do
that point sort of support their ability to look at how are we contracting here in the state of Florida and how can we improve it? We can inform ourselves, the cases that were cited here, Watkins and the Hageman case, they identify different legislative interests, informing themselves, investigating, legislating, and it seems that here, if they're trying to legislate better practices, that they might look into.
But again,
Contracts.
in this case, again, we don't think that this is the particular correct case to do that because, again, Visit Florida got every product they got that they contracted for. They got it at the contracted price. There was no disputes as to deliverables. There was no dispute as to the way it was procured. Again, trying to stay within the record with my response.
Sure.
And
No, and I get that
Yeah.
when you're essentially contracting for performance, art, advertising,
so this
that
wasn't
trying to cost it up doesn't really make, when you're talking about art, you look at the fact that a Renoir, what's the cost of the canvas and the paint? Well, no, that really doesn't get you to where you're going.
And again, in this, there is a lot of creative aspects to the marketing, to the creation, to the way it's presented. I mean, it is art in a sense. It's not a picture, but it is art. It's a television show. And
But we
another
also
ancillary-
have to be mindful of the United States Supreme Court's teachings in Florida Supreme Court that the legislative inquiry is subject not only to existing laws, but proposed laws. And so even if everything was done by the book, and I'm not suggesting it wasn't in this case, but the legislature doesn't have a right under its broad investigatory power to look behind the curtain to see if new laws might make the process better.
Our position is that in this case, they don't, okay? There could be cases where the legislature uses its subpoena power to compel private individuals and private entities to bring records before them. We don't believe that this is the case. Again, it all stems from the fact that the contracts were completely executed and done correctly. They were accepted by Visit Florida. This is a dispute between, I guess, the legislature and maybe Visit Florida, in which Mr. Roberts is caught up in the middle. But in terms of Mr. Roberts and Matt Media's compliance with the subpoena and the legislative power, we think that they've gone too far with respect to the pertinency analysis that is in those Florida Supreme Court cases, as well as otherwise expressed in United States Supreme Court cases when it talks about being relevant to the investigation. Again, the Florida Supreme Court has indicated that the power of the legislature is not unbridled. It is subject to restriction. It can be reviewed by the courts. In your questioning of appellants, you indicated, or appellant indicated, that it was wrong for Judge Gievers to look behind the curtain and see what these documents were all about. I don't know how the court would otherwise make the determination as to whether they were relevant to the investigation that was purported and asserted by the House. Because again, we're talking about a series of financial records here that, again, were sought, again, for the integrity of the contract and the quality of the procurement. Again, Mr. Roberts and Matt Media's costs that he paid to his employees, to his subcontractors, and things like that are not necessarily pertinent to that inquiry.
Let me ask you a question. Hageman, where of course you know that Florida Supreme Court allowed the legislature to look into the bank records of the Governor's Club, do you know if the court allowed or if it involved an in-camera inspection at the trial court level and making the determination of pertinency? It didn't appear from the face of the opinion if that occurred.
I don't see it in the opinion that that's what occurred. I think there's probably been quite a bit of evolution in terms of the ability of courts to look behind documents or look behind the curtain in certain cases between confidentiality agreements and keeping things confidential in court records that weren't available back in, I guess, the 1960s, back in the day when I was but a teenager. With respect to, I guess, the actions of the trial court here, we would submit that there's nothing new or novel in what Judge Gievers did in terms of looking at this case. I mean, she looked at the Constitution when it talks about lawful subpoenas. The question of this court, and I think the question that she had to deal with was, what does lawful mean? I mean, does it just mean what the legislature says is lawful, and we'll determine what's lawful and what is complied? But she looked at this Constitution and statutes. She looked at the standards that the Florida Supreme Court has.
Well, let's talk about the Constitution for a second, because that seems to be underlying this a little bit. And whether I agree with Citizens United or not, discuss its applicability to this case. I mean, the other side made a pretty good argument that that right is different than the other personal rights we have here.
Are you talking about the right to privacy as it applies to Matt Media's
Whether
records?
it's individuals or, yeah.
Okay. Well, in terms of what we're talking about is, I mean, clearly Article 1, Section 23 only applies to individuals, without a doubt. As we went through this process and started this process, as you know, they did seek Mr. Roberts' personal tax information. We're kind of splitting hairs here when we're talking about we're not seeking his personal tax records here because, again, Matt Media does not file a separate tax return. It is
Okay, the tax returns have been pulled.
Well, no, but let me get to the personal records here. The Schedule C is part of Mr. Roberts' personal tax return. It's just, it's a schedule within the middle of it.
Well, I'm sorry, and maybe I misunderstood Appellant's counsel, but I thought paragraphs 20 and 19 are off the table. We're
I understand, but I was
focusing on
talking about the
paragraph
right to privacy and how it plays in here, okay?
Okay.
So again, as this is the first time really I heard that 20 was off the table, because in my presentation I thought we were going to talk about 18, 19 in the one subpoena and 18, 19, and 20 in the other subpoena. And so this is really the first time that I think I've heard that 20's out, okay? Now, with respect to the ability of the corporate records to be protected, okay, I will concede that corporate records are not subject to Article 1, Section 23. But again, that's not to say that they are fair game in any legislative inquiry.
I understand, but the protections afforded them are somewhat different.
They are, and again, the protection then would come back to a relevancy analysis, a pertinency analysis, which in fact is what Judge Gievers did. And the only way to get to that posture, whether we're talking now 16, 17, and 18, is that the judge has to look at those records, make that analysis in the sense of pertinency, relevancy to the inquiry. And in this case, the judge indicated that they were not pertinent or relevant. And so I hope I've answered your question that you've asked. Again, I was saying that again, Judge Gievers looked at the existing Florida law from the Florida Supreme Court. She applied those tests that are set forth in the Johnston versus Gallen case, the Gibson case, and the Hageman versus Andrews case, and believed that she came up with the right answer, and we do believe that. In appellant's brief, they talk about this Morton Salt case and what the appropriate test should be in terms of looking at these types of subpoenas. Albeit we're being criticized for the fact that they're looking behind the door, but looking at the Morton Salt case, United States Supreme Court, we believe it really doesn't support the power of the legislature to do this broad type subpoena on a private record. If you look at the facts in that case, there was an ongoing enforcement action by the FTC against the salt companies for price fixing. That had been resolved. The FTC then in turn wanted to get some more information. That was the question, but it was involved a an ongoing price-fixing litigation case in the FTC, for which they clearly had jurisdiction. With respect to the test that I think that the House proposes here today, it is a broad test that essentially has no checks, because again, the legislature have shown they can actually legislate on almost anything. So therefore, I think they have the power to subpoena almost anything.
I think the problem for me with that is here we're talking about a government contract and where they're looking to investigate and inform themselves regarding an entity that the state contracted with. I mean, we're not talking about just some random company out there who, hey, let's see how they do their business and we want to know what their profit margin is. This is a government contract where there was a sense of maybe some internal dealings and different things going on here. And so in making your remarks about the test, I can see a difference between doing this with a government contractor versus asking for this information regarding some company that has no dealings with the state.
And again, that comes back to, I can concede that point to you, Judge. You're the judge. But the issue then becomes, where do you draw that line even with any company contracting with the state? Because again, I don't think the difference is the fact that they had to retain these things by contract for an audit. That might be in every contract that's ever been driven by the state. I can't tell you yes or no. But you put at risk every contractor that say, hey, we want to go behind the contract, see what your costs were, see who you paid to do this, and that just was a bridge too far in Mr. Roberts and Matt Media's opinion. Again, the key issue in this case is the extent of the legislative power to subpoena records from private individuals and entities. In our view, the House argues that the legislative subpoena power is virtually unlimited. Matt Media thinks it is not absolute. It is limited by the Constitution, and it also has to be pertinent to the inquiry. And in this case,
would it have been mattered if the subpoena just said, we would like to, all documents related to your cost of executing this contract?
we would have objected to that as well.
That's what I thought, but I just wanted to.
Again, I think that's the issue here, is that the
No,
House.
I mean, I'm just trying to get the issue clarified. in my
Yeah,
mind.
the House has got an issue with Visit Florida, and again, Mr. Roberts is the punching bag for that issue. And without any further questions, I'll sit down. Thank you.
Thank you, Mr. Ahern.
What the House wants to know here is the cost incurred in the production of Emeralds, Florida, which the Florida taxpayers paid for. Matt Media received a fair amount of money in taxpayer funds to produce it, and Matt Media is the only source of the information of how that money ultimately was spent to produce the programming on behalf of the state of Florida. The question that Judge Osterhaus was asking about scope and Mr. Ahern's response about, well, there's then no limit, like then the House could subpoena any business and start going into their business records. The interesting theme in that exchange is the focus is still on the question itself, and certainly if there were a subpoena to just a company, a random company, let's say, that didn't engage in a public contract, it was just a company out there and the House selected one and wanted to know about all its financials, it's not going to require an inquiry into the financial records to determine whether that subpoena is within the legislative power or whether there's overreach. The focus there, as it should be here, is on the question itself. And the two-part, I've called a two-part test. The first is what is the investigation? Is it within the legislative power? And it seems fairly clear that public contracting and that type of thing is within the legislative power. And the next question is that specific request tied to that inquiry? And the answer here is yes, of course. I mean, it's the inquiry itself, right? It's specific to that particular, that set of public contracts. And so that should end the inquiry unless there's some constitutional issue, which has not been identified here. Hageman controls. In that situation, you have the House Elections Committee subpoenaing bank records of a private club. And if you think about it.
So this goes back to the question I asked at the very beginning.
Yes, Your Honor.
Is it the position of the state or the legislature, the House, that the inner workings of a company that does business with the state would be subject to legislative subpoena at any time? Anybody that has a public contract with the state of Florida?
I don't know if we can make that broad a statement or that broad a rule. There's certainly at a general level, though, a public contract and a vendor contracting with the state, their records dealing with the costs and how they perform under the contract. In an appropriate inquiry, if the House is interested in knowing how that public contract is being performed or how it was being negotiated, yes, any vendor should be on notice that they may be subject to subpoena. And regarding confidentiality of records, that shouldn't really even be an issue because there are protections to ensure that that information is not publicly disclosed, but it's certainly the House is entitled to it. It's in the statute. It includes confidential information. And it's possible, and it would be subject to an exemption to the public records law as well. So vendors, yes, vendors should be on notice that it's possible that their records could be subject to subpoena.
Thank you,
And for these
Counsel.
reasons, the House asks that the court reverse and remand with instructions that the records are responsive to, at a minimum, paragraph 18, but 16 and 17 as well, and the subpoenas be enforced. Thank you.
Thank you. Thank you to both counsel for your presentations today. Court stands in recess.
All rise.